without proper estate planning, family members pay the price. Oftentimes, the result is an expensive probate court battle to obtain guardianship, and eventually, the settling of an estate after a loved one's passing. From those with modest means to the very wealthy, this happens to families on a daily basis. Peck Ritchey is here to help. We can serve and guide your family both in and out of the courtroom so you can find peace at home.
Everyone, thank you so much for coming to the Elderwerks Aging Better Senior Fair. I'm Gail Nixick, Vice President of Elderwerks. I know a lot of you have been to a lot of our seminars in the past and our senior fairs, so we're very happy to have you here at this lovely venue. If you like the venue a lot, make sure you put that on your evaluation. We'd love to hear from you. I have the pleasure of introducing our speaker this morning. Our speaker is Kerry Peck. And Kerry is the managing partner of Peck Ritchey. He's the past president of the 22,000 lawyer Chicago Bar Association. His clients have included families, hospitals, banks, state of Illinois, county of Cook, city of Chicago. Since 2006, he's been selected by his peers in a statewide surveys of Illinois attorneys as a super lawyer, an attorney to whom other attorneys refer to as family, and is named member of Leading Lawyers Network. Kerry is also co-author of the Alzheimer's and the Law, Don't Let Dementia Steal Everything, both published by the American Bar Association. Peck Ritchey does have a table in the exhibit hall, so you will see the book there. Kerry has also been appointed guardian ad litem in the circuit court by the probate division, chancery division, and county division, including complex cases including healthcare, tax issues, real estate, and medical issues. Kerry has been appointed the special administrator, successor, administrator and/or successor trustee in contested trust in estate cases by court order. And I want to also mention that this is a very interactive presentation. Kerry is happy to answer those questions. So if it's at the time of the slide, if you happen to have the question, please do ask, but want to be mindful of the time. So welcome, Kerry. Thank you so much for joining us this morning.
Thank you, Gail. Thanks for the kind invitation and the great introduction. Good morning, ladies and gentlemen. As Gail said, I'm Kerry Peck. It's a pleasure to be with you this morning. And we're going to hit the ground running in the context of our educational program this morning. As Gail says, if you have a question, let me know. Let's try and see if we can answer the questions related to the slides and when the subject comes up. So, we're talking this morning, as you know, about estate planning, and estate planning, as our opening title says, it's only scary if you don't have one. And there's a lot of people that don't have estate plans. How many people in the room have an estate plan? Okay, good. There's an awful lot of hands that didn't go up, please. All right, let's hit the first slide, please. So today we're going to talk about what is estate planning, strategies, and the documents in conjunction with estate planning, modern planning considerations, probate court, what is probate, and the court complications that may arise out of a probate estate. Next slide, please.
Sorry.
So, unfortunately, we hear this quite a bit, and that is, the unthinkable, so to speak. Nobody thinks that they're going to get sick. Nobody thinks that their loved one's going to get Alzheimer's or dementia. We do a lot of work with the Alzheimer's Association. And take a look at this slide. We thought we had more time to plan. My husband's been diagnosed with early onset dementia. Can we get our estate plan completed very quickly now? Well, the horse is out of the barn, as the saying goes. We got trouble. Next slide, please. You want me to take that?
If you would like, actually here, we have some slight tech issues with the stream right now, but
right.
I can.
Then maybe we'll let you control.
Yeah.
Okay. So as you can see on the slide, 1 out of 4 Americans without a will never plan on getting one. And more than 40% of Americans say they're going to get one when they get a medical diagnosis. And depending on what that diagnosis is, it affects cognitive ability. It may be too late to do estate planning. That's one of the biggest concerns with estate planning. Next slide, please. So what is estate planning? Well, estate planning really has a variety of purposes. As you know, it's to distribute your estate upon your death. It's also to try and reduce taxes, potentially asset protection, avoidance of probate. We'll talk about probate a little bit further, as well as advanced planning for the management of both your health care and the management of your assets. And those would be documents relating to what we call powers of attorney. In Illinois, we have two types of powers of attorney: a durable power of attorney for health care and a durable power of attorney for property. The term property is generic. It does not relate exclusively to real estate. Next slide, please.
Yep.
So even before estate tax existed,
Is this not the right one?
did we pass one?
Oh, there we go. Sorry.
Okay. So even before estate tax came into being, there obviously are other purposes for planning. And people generally, again, focus on who's getting what when I die, okay? I mean, bottom line, that's it. But with proper estate planning, we can potentially protect assets from creditors. We can preserve family wealth and pass it down to future generations. We can provide for support and income to the family under all circumstances. Typically, that's important should circumstances go bad. And we can manage assets for those who can't manage their own assets. Important, again, under powers of attorney, or perhaps through the use of a revocable living trust. Finally, we also often use estate planning to do business succession planning in conjunction with what we call a buy-seller. Next slide, please.
Yep.
So I think we really do get it. So when we do a small estate, we focus on how and who's going to manage your assets at the time of your incapacity and at the time potentially thereafter of your demise. So under what circumstances does it make sense to distribute assets during lifetime? Sometimes we want to do that so that we can again avoid tax issues, perhaps avoid gift tax related issues. How and by whom your personal care and health care is going to be managed. Important. How many people in the room have a power of attorney for health care by a show of hands? Okay. Again, a lot of hands not going up. How many people have a power of attorney for property? Good. Same people. Not surprising. So who's going to be guardian if you have minor children? Perhaps you're in charge of grandchildren or a grandchild. Who's going to manage that? In multi-generation families, we see a lot of those issues. And focus on a large estate plan. We might preserve the estate assets in a way of reducing taxation. And tax planning is a big consideration if you're fortunate enough to have earned or inherited a large sum of money, please. So often we are asked, what is the capacity needed to engage in estate planning? And it's an important question because as we opened with, if someone's diagnosed with Alzheimer's disease, early onset, or Parkinson's, which affects mental capacity, things of that nature, the question, of course, is, does that individual retain the cognitive skills to do estate planning? And at the end of the day, we need to take a close look at that. People that have been diagnosed with a cognitive impairing illness, often we have to get a note from their doctor that says they have the ability to do estate planning. So don't wait until somebody tells you, well, you've just done some testing and you now have been diagnosed with early onset Alzheimer's disease. Big problem. Yes, sir. Next. So in Illinois, we have what we call testamentary capacity or contractual capacity. And the ability to understand what you're signing and the implications in doing so are testamentary capacity. We're often in the courtroom arguing in litigation, did mom have testamentary capacity at the time she signed her documents? If not, those documents can be held invalid. It takes a judge to make that decision. Likewise, what's contractual capacity? Contractual capacity is a little lower for purposes of estate planning than testamentary capacity. But the Probate Act says testamentary capacity is typically defined as being of sound mind and memory, and the individual has to know they're doing a will, they have to know their family, they have to know what their assets are, and the tough one is they have to be in a proper mental state to form a plan in their mind. That's where we go to the doctors, hopefully the attending doctor of someone that has had a long-standing relationship. Next slide. So diminished capacity and incapacity runs along a continuum. It's not all or nothing, and everybody's different, and everybody responds to illness different. Everybody responds, for example, UTI infections often cause confusion. Other types of infections often cause confusion. Is it a temporary situation or is it a permanent situation? And that's a critical question to determining cognitive capacity, your mental capacity to do estate planning. So lawyers are often called upon, not just in estate planning, but in a daily practice of law. Well, does my client have the capacity to sign the deed to sell her house? Okay. Then you go to, does my client have the capacity to sign a will? Does my client have the capacity to sign a revocable living trust? So again, sliding scale. We need to get to know our clients, and if we have concerns, we're going to ask you to get a medical report that indicates you have the capacity to engage in the act, okay, perhaps signing the deed, signing the will, that you are coming in to see us about. Okay, again, any questions? I like this to be as interactive as possible. I don't want to give a monologue speech at you all morning. In back.
You keep mentioning in Illinois. Is it different in different states? I know we're in Illinois here, but say if we did something in Illinois and moved somewhere else, are the rules different in different states?
There are different rules in different states. A lot of people retire to Florida or Arizona, but all of them require that you have the mental capacity to understand and understand what you're doing. Signing a will, again, I sound like a broken record. Know your assets, know your family, and have the ability to form that plan. So I'm licensed in Illinois and Florida. I can tell you it's virtually, it's not identical, but it's virtually the same. Any other questions before we proceed? Okay.
Sorry.
So this is a pretty common scenario of documents. Last will and testament, I think everybody's kind of familiar. You've heard that phrase. A will, last will and testament, or your will, has no validity during your lifetime. None whatsoever. Okay? It springs to life after you take your last breath. But in many instances, it requires a court proceeding, a probate proceeding, to appoint the executor. The executor is a person you name under your will to manage the assets after you die. Okay? This is a very important point. In Illinois, if you die with in excess of $100,000 in assets of any kind, cash, real estate, stocks, bonds, doesn't matter what it is, if you die with in excess of $100,000 in your name alone, Illinois law requires that a post-death probate proceeding be open in the county in which you died a resident of. So, we're out here up the street from Kane County, DuPage County, could be open it in Wheaton, you open it in Geneva, downtown it's at the Cook County Daily Center. The entire 18th floor of that large building is probate judges. Some of them hear post-death probate, and some of them hear what we call a lifetime probate, which is guardianship. Does Gail need a guardian? If so, who should it be? That's a lifetime guardianship case. You want to avoid that by using your power of attorney documents, by executing documents that you can avoid it. You can avoid that probate post-death $100,000 threshold by using a revocable living trust, okay? A revocable living trust is recognized in all 50 states, and it's basically premised on a legal fiction. You take your assets and put them in the revocable living trust. What do? You retitle your asset. So your house goes into your trust. My trust says Kerry Peck, trustee of the revocable living trust, dated August 8th, 2023. And what have we done when we put our assets in our revocable living trust? We avoid that post-death probate. We don't have to worry about that $100,000 threshold. Now, we can also pass our assets by joint tenancy, okay? If Gail and I own the house together and I get killed on the way home or back into the city today, she gets the house, joint tenancy, okay? We can also use what's called POD accounts, payable on death accounts. That avoids that probate issue. So there are other methods of avoiding that probate other than a revocable living trust, but it's very important that you consult an attorney to get your ducks in a row, okay?
So, sir, the will doesn't cover all. So if you had said, you know, if I made that the house goes to, you know, Sister Sue, that doesn't stop the probate?
No, if you own a house at your death and it's in your name, okay, then it's going to require a probate. I'm going to assume every house we're going to talk about today is over $100,000. So, but yes, that would require a probate. Will does not do it, does not avoid probate. So most wills will be probated if they're not in conjunction with a revocable living trust in order to appoint the executor, the person you've named post-death, to manage your assets. Sure, yes, ma'am.
How frequently is it necessary to review or update revocable trust?
Great question. Can everybody hear? Everybody heard in the back?
No.
Yeah, no. Okay. Question is, how often should we review our, she said revocable living trust. I'm going to make it broader to your estate plan. Okay. You should review your estate plan when your life circumstances change. Okay. Death, divorce, remarriage, marriage, birth of a child, birth of a grandchild. Those are the kind of big circumstances that you should have your estate plan reviewed. Okay, sometimes it's 3 years, sometimes it's 5 years. If there are no life circumstances, you should have it done probably every 5 years because the law changes. Okay, and we lawyers know what the law changes are, but in general, unless you see it on the front page of the newspaper, and most people today are reading the newspaper on their phone, okay, then you may not know that the law changed. So it's important to stay current on those issues. Yes?
You mentioned the POD accounts avoid the probate. Is that true if you just set up a local bank account and they put POD on a local bank account, but then that avoids the probate because it's in the bank account?
Yes, the answer is yes. So the question is, if you name a POD, beneficiary, payable on death, at a local bank, does that avoid probate? The answer is it does. Okay, but it's important that you get all of your assets in a format that avoid that $100,000 threshold. In other states, that threshold's lower. So it's important that then you realize where you're going to live and what applies. Yes, ma'am.
I've done this law before, but with somebody else that was in charge. But if I find that you can do all the will stuff and POD, but something's going to pop up that is going to that you're not going to know about.
Agreed. And the comment, can you hear it back?
Yeah.
No. This young lady said that she's been involved in these kinds of situations and something pops up inevitably, causing you to probably go to probate court. And I agree 100%. You'll recall moments ago I said you need to make sure all of your assets are properly titled. All of your assets are either in your trust. All of your assets are in joint tenancy. All of your assets have payable on death beneficiaries, so that you can avoid that probate if that's your intention. Over here.
So like life insurance and like 401ks where you have a beneficiary.
They will avoid probate.
It will, okay, thank you.
My mother got a lady bird deed, which, you know, which one that falls under, or it's not?
No, there's a lot of different types of I don't know the specifics. I've heard the phrase, but it's not one that lawyers use. Yes?
Is there anything you should not put in a trust?
You should not put your car, you should not put your retirement accounts, and in general, those are the two largest categories, particularly your retirement accounts, your 401ks, your IRAs. They should not go into trust. I'm going to say it again, not go into trust. Why? You will incur a tax liability by transferring those assets. Make sure you avoid it, okay? Do not do it.
Just do the beneficiaries.
Just use the beneficiary. Again, in your 401k or your IRA, you can just use the beneficiary. That will avoid probate for those assets. Again, I think that, an important point this lady made is something always pops up. So the reality is you really need to sit down and do comprehensive planning, literally soup to nuts, A to Z. We need to know everything. Yes, ma'am.
Yeah, I have a question on the revocable trust.
Mhm.
If the original trustees passed, and it does it just go into the subsequent trustees that name on the trust?
So the question is, if a trustee of a revocable living trust passes away, does it become, does a successor trustee take over? The answer is yes.
Then do you need an attorney, or you just take the document to the bank and say, look, I take over these accounts? What's the procedure?
I would think you should get a letter from a lawyer saying I reviewed Jane Doe's trust, and John Doe passed away. Sam is now the beneficiary, the successor trustee, and here's a copy of the trust. Because a bank is likely going to want a copy of the trust to change the title of the trust, change the title of the accounts.
So get an attorney to
Yeah.
say that, and then
Right.
that
And then get that over to the bank.
Does it has to be an estate planning attorney or any attorney?
The question is, does it have to be an estate planning attorney, or can it be any attorney? So the answer is, are you going to hire a podiatrist to do heart surgery?
Okay, we moved from Minnesota,
Mhm.
and with the people that draft our trust,
Mhm.
they're no longer in business.
Okay.
So I would have to find another estate planning attorney.
I would think it'd be a smart move, particularly because you don't know what the laws of Minnesota are applicable here
That
or
was my
not
next
in
question.
Illinois.
So
Yes.
uh,
You
the
should have
trust
somebody
that draft,
review that.
we should have somebody here.
And I would
Illinois
suggest to
do it.
you somebody that does estate planning work as a concentration of their law.
So it could be different, the two states.
Yeah, it could be different, yes,
Revocable trust.
yes. There are likely to be some strong similarities, but there may be some differences. I can't opine on Minnesota law.
When would you use irrevocable?
Sorry?
When would you use irrevocable?
Irrevocable trusts are often used to protect assets, okay? Protect assets from a creditor, things of that nature. They're not used very often. They're also used potentially in qualification for Medicaid benefits, things like that. If somebody asks you to sign a revocable living trust, or revocable trust, not living trust, your antennas should pop out of your head. You want to know why, okay? Because irrevocable really means what it says. I've been involved in a lot of litigation in which the court says, it says irrevocable, we're not allowing it to be changed. Okay, let's go to the next slide, Gray.
Yep.
We'll get in a minute, man. So again, your will is operative upon your passing. It appoints an executor, okay? If you die with no will and assets in excess of 100,000, the court's going to appoint an administrator. So your will names an executor. Pick somebody you trust, okay? Don't pick one of your relatives because they live down the street. Pick somebody that has some financial savvy, some business experience in the management of assets. Because that individual, subject to generally court approval and court oversight with the assistance of a lawyer, is going to administer your assets. So the last will and testament directs payment of debts, any liabilities, distribution of assets upon death, everybody knows that, and is a public document, okay? Revocable living trust is a private document. Very significantly different issue. The law in Illinois requires we file the original will with the court, regardless of whether we're opening a probate estate within 30 days of your date of death. So this document is going to be public. And note the bottom important, it does not avoid probate unless you have a revocable living trust with it, or you've named all the beneficiaries in the fashion we've already discussed. Next slide, please. So this is kind of a side-by-side comparison of a revocable living trust, an irrevocable trust. As I said a moment ago, you know, the primary benefit for irrevocable trust is to protect both assets and potentially creditors. The revocable living trust, you can see all of the positive benefits, and again, the avoidance of a probate case with the use of a revocable living trust, okay? Probate cases must be open, meaning you've got a court case going on, assume you're deceased, your relatives have, for a minimum of 6 months. Minimum of 6 months. And all of your creditors, whether it's a bank loan, a car loan, a doctor's bill, a funeral bill, et cetera, have 6 months to file claims against your estate to get paid. Most cases last far longer than 6 months.
So, sir, the living trust or revocable living trust, who maintains that document? Where is it stored? You keep saying a bank. Is that?
Well, you can use a bank as your trustee in conjunction with a revocable living trust. Let's drill down on it, okay? It's a document in which you name a trustee to manage your assets after you're dead. During your lifetime, under a revocable living trust, you name yourself as your trustee. And why do you do that? Because it avoids guardianship. That lifetime probate. Lifetime probate is guardianship. What is guardianship? Again, does Gail need a guardian? If so, who should it be? Is she cognitively impaired and unable to manage her assets and or her health care? So where is the original document kept? You can keep it yourself. You can ask your lawyer to keep it. You can put it in your safety deposit box. Okay?
Thank you.
Safety deposit boxes, it's going a little out of vogue. Not a lot of people have them anymore, but some people do. And we find that if you put your power of attorney documents in a safety deposit box, you never have them when you need them. Because the bank's closed on weekends and the bank has short hours. Don't do it. Questions? I think you had a question.
Yeah, I was wondering if you could go over the legal requirements for the will.
Testamentary capacity? Is that what you're talking about?
Yeah, the requirements in order to make a will legal. Because a lot of people make wills and they, when they go to probate, they can be easily contested or and invalidated for this reason or that reason. So what we
Well, there's two bases to attack a will. And my law firm does both the estate planning and the litigation, the lawsuits, the courtroom work in this scenario, these cases. There's two ways to attack a will. One is lack of mental capacity, okay? And that mental capacity, I'm going to say it again, require, I know that I'm doing a will, I have the ability to form a plan in my mind. I know what my assets are, and I know the fancy phrase is natural objects of my bounty, which means I know my family. Okay? That's one basis to attack a will. The second basis to attack a will is usually what we call undue influence. The children from the second marriage persuaded mom to disinherit the children from the first marriage. They unduly influenced mom to disinherit her children from her first marriage. A very, very, very common scenario. Multiple marriages breed a lot of litigation. So watch out.
I guess, on your question, if you go to the internet, you type in will, you can get 50,000 versions of doing your own will online, and, just printing out forms, filling in the blanks. So I think it's part of that is.
Right. And some places require 2 witnesses, you have to do it in front of
Illinois requires 2 witnesses, and the document must be executed with the phraseology, the individual is of sound mind and memory. And the 2 witnesses must attest, literally, by writing that they've observed Kerry Peck sign the will, and that he's of sound mind and memory, okay? And in general, there's also a notary. We use 3 witnesses to execute wills. 2 witnesses relative to competency and a notary, okay? Your comment about do it online and get multiple versions, I'm here to tell you I've been a lawyer, and frankly, a pretty substantial lawyer in the world of trust and estates. I've never, not once, okay, I've been a lawyer over 40 years, never, not once, seen a do-it-yourself will work. Never. Get yourself a lawyer. Spend the money. Hire somebody that you have trust in. Hire somebody by way of references. Hire somebody that is well known in the community for doing this type of work. Do not write your own estate plan. And because you won't know it didn't work, you're dead. In back, yes, ma'am.
You mentioned about paying for this. Can you give an idea about how much it costs? I'm sure it depends on the situation.
Depends on the situation, depends on the documents. But I think that the costs probably start in the $2,500 range and go up depending on complexity.
Thank you.
Sure. Next slide, please. So I don't know, there's a fair number of people as old as I am, if you remember the Doubleman twins. Okay? The Doubleman twins. You're going to do the dance? I'd like to see it. There you go. Great. All right. I want it noted, Gail, that this room was so fun we had dancing.
Absolutely, no question about it.
So when you appoint someone to make legal decisions for you, when you're not capable of making them yourselves, it's like you're appointing a legal clone, okay? Like the Doubleman twins. There you go. So you choose somebody wisely, okay? Choose somebody wisely. You may not choose the same person to manage your health care when you can't do it yourself, to take you to the proper doctors, as you would name to manage your assets. People have different skills. They have different ways of thinking. You can name the same person if you wish. Most people name their children. Some people name their spouses, obviously. But it's important because you're giving that individual a lot of power. And sometimes we see people abuse that power, regrettably. So choose your agent. It's called an agent under your power of attorney for health care and or property very carefully. Next slide, please.
Can I ask a question regarding that? This has come up actually recently. So correct me if I'm wrong, but we have some people who say, power of attorney for healthcare. I'm not really up to it anymore. There isn't named a successor. In that particular case, would then that possibly be guardianship? And the person just says, I'm just not feeling that I can do what's right for this individual. And they're being honest. They just don't think, not that they don't want to, they just don't feel that they're the qualified person anymore. So is that
Yeah, it's a common scenario, and if you have an agent who can't do it anymore, who potentially passes away as well, we may end up in guardianship court. Again, a guardian is Gail able to make decisions regarding the management of her assets and or her health care. If you don't have these documents, you're going to guardianship right from the get-go. If you have these documents, potentially you avoid it. These are guardianship avoidance documents.
Do power of attorneys expire?
I'm sorry?
Do power of attorneys expire?
Generally, they do not.
Okay, thank
When you're talking about guardianship, are you talking about somebody unrelated to you being appointed by the court?
Question is, when I talk about guardianship, am I talking about someone unrelated to be appointed as guardian by the court? And the answer is yes. It could be unrelated person. It could be one of your relatives. It's up to the judge's discretion. Again, that inquiry is two-pronged. Do you need a guardian? If so, who should it be? And usually there's a battle over both phases of that.
How does the court system give you a guardian for health care if they really don't know you, and they don't interfere with doctors and things? How does that work?
Question is, how does a court pick a guardian, particularly for health care? The answer is that in order to appoint a guardian in Illinois, it is required that you submit a medical report regarding your cognitive abilities. Okay? A medical report that may also suggest what would be an appropriate living situation. And the terminology, the legal terminology is, are you totally incapable or partially incapable of making decisions regarding the management of your assets and or your health care? So it is based on a medical evaluation. Usually, I like people to go to their attending doctor. Sometimes it doesn't work out that way. Sometimes the court appoints a doctor to evaluate you and write a report to the judge.
Doesn't your power of attorney expire when you die?
Yes. Power of attorneys die when you die. They have no validity post-death. So I've talked about it early on. We have two types of powers of attorney in Illinois. Power of attorney for property, not just real estate, all your property, and a power of attorney for healthcare. You can see in this slide how we use that power of attorney for property. And I think that it's a terrific device, but I'm saying again, probably for the 12th time, pick someone you trust. You're giving them authority to manage your assets. And regrettably, sometimes that individual steals the assets. Next slide, please. So power of attorney for healthcare, again, we're appointing an agent and a successor agent. Your primary agent is going to be the person to take over generally when you're not able to make your own decisions. And a successor would take over when the primary agent either dies or potentially resigns, isn't up to it, moves out of state, things of that nature. Your agents can reside out of state, but practically it's usually a problem in terms of getting things done. So again, we want to do this because it potentially can avoid a lifetime probate, that guardianship, because I've named someone to make decisions for me when I'm not able to make them for myself. Again, in the arena of asset management, generically called property, and healthcare. Next slide, please. So, selecting trustworthy agents. We've talked about it. Who's capable of acting independently? Who's the best person? Select a successor agent. Okay, and I've mentioned it, and it's unfortunately, it's a hot button. We see a lot of financial exploitation. Make sure you have confidence that you're choosing the right person. Yes?
Besides keeping these documents in your own home, should you give each power of attorney person a copy of that thing that says that they are?
Yes, you should. And you should give your primary, your internist, a copy of your power of attorney for healthcare. Don't forget, your power of attorney for healthcare, you're going to be asked what type of end-of-life decisions and treatment do I want? Okay? What type of end-of-life treatment do I want? Do I want to be a do not resuscitate, a DNR patient? Or do I want the hospital to go the distance, and you see it on TV, code blue, when they run in with the crash cart, and elderly people, regrettably, they break their ribs in order to do cardiac starting. Yes?
The copies that you disperse, do they have to be quote unquote originals, or can you have?
No, they do not have to be original.
Okay.
But know where your original is, because somebody is going to want it. A hospital, a bank, a doctor, know where it is. Yes, ma'am.
Well, you would have the original, but would your lawyer keep it original as well?
Generally, lawyers don't keep original powers of attorney, because I know you're going to need them out in the community. Next slide, please. So, power of attorney document can limit the authority of the principal. We have what we call a principal-agency relationship. Person that signs the power of attorney is the principal, not of the school, but an agent. So principal, you're creating an agency relationship. That's the terminology in the law. And that brings with it certain duties and responsibilities. You have the ability to limit that power of attorney's rights. You don't want them to sell your home. You don't want them to put you in a nursing home. Things of that nature. Circumstances change, though, so be careful when you limit that POA to make sure that that individual has the power to do what you want them to do. Coffee break with water. Yes, ma'am.
In situations where there's a crisis in the hospital and these documents exist, but all of a sudden.
I'm sorry, could you talk louder, please?
In situations in a hospital where a patient already has the power of attorney, has made some resignations, but is in such a crisis that they want to change their mind, who does the family go to at that point?
Probably can't change your mind if you're in such a crisis. You have to have mental capacity to do a power of attorney. So again, those are, this is a scenario, this is kind of your wake-up call. Don't wait. Person goes in a hospital, they have a power of attorney for healthcare, they're not going to be able to change it if they go into crisis.
So the family must have to call the legal department in the hospital?
The legal department will jump in with both feet. I can tell you that for sure. All right, next slide. So living wills are kind of a superfluous document, I think, but it's only applicable in the event of a terminal illness. And again, it lays out your preference for end-of-life decision-making. None of us want to talk about it. None of us want to think about it. But I'm telling you, ladies and gentlemen, you have to do it, okay? Decide, talk to your family, talk to your doctor. A lot of people bring religious beliefs, moral beliefs, ethics beliefs. How do I want to go? Do I want to be a do not resuscitate? Do I want to be resuscitated? Today, medical equipment can keep us alive, which means we're breathing and our heart is beating for a long, long time after your quality of life has completely diminished. It's up to you to decide how you want to go out. Next slide.
Can I ask a quick question?
Yes.
The difference between a living will and do not necessitate?
That you could denote your wishes in a living will, but I would encourage you to use power of attorney for healthcare. It's clear and it's recognized everywhere. And go ahead.
There is a form that says do not necessitate.
There are do not resuscitate orders, yes.
Yeah, and the doctor said, oh, you don't need a living will. This is good. So.
Some of it is tradition. Some of it depends on what the hospital says. Some of it depends what the doctor says. But I would encourage you to have a power of attorney for health care in which statutorily you're given by the state legislature, the folks down in Springfield, choices. This is my choice. This is what I want. This couldn't be clearer than that. So this is an interesting, if you don't have a power of attorney for health care, okay? In Illinois, we have what's called the Healthcare Surrogate Act. This is literally a chart. If I, again, don't have a power of attorney, I get back on the highway and I get crushed by a truck and I'm taken to a nearby hospital. They don't know that I have a power of attorney, okay? The question is, who's going to make decisions for me if I can't make them myself? And this is literally a chart in terms of priority to make decisions. Now, this one's kind of interesting because you can see the guardian starts kind of the kickoff, but most people don't have guardians. Very few people have guardians. But a lot of people have spouses. And a lot of people are in the middle of divorces with those spouses. And I can tell you that that spouse retains that right to make decisions. Not what you want in the middle of a divorce. Get a power of attorney for health care. Okay? So it goes all the way down, children and so forth. Most people would be comfortable having one of their kids make decisions, especially if they're in a contested scenario with their spouse. Any questions on that? Okay, next slide, please. So we talked about payable on death. This is another variation of transfer on death, and commonly referred to, amongst lawyers at least, as a TODI, transfer on death instrument. You can use it for your house exclusively, okay? So that's important. Talk to your lawyer about whether you want to use it. I don't necessarily see a lot of them, but we have that provision here in Illinois. Next slide, please. Joint tenancy accounts, we talked about it a bit earlier. Joint tenancy is A and B, husband and wife usually. Gail and I, not husband and wife, own our assets in joint tenancy, a bank account. Now you should know that if you own a bank account with a joint tenant, that joint tenant has 100% invasion rights to take all the money. Choose your joint tenants carefully, okay? We often get calls and get involved in situations where the joint tenant has stolen the money. Yes?
Another scenario, if I'm joint tenant on accounts of my mother's, does that affect my family's ability to get financial aid for children, stuff like that? Are those assets part of my assets?
They are.
Thank you.
Sure. So, again, joint tenancy really is upon death, it passes and avoids that probate. And choose your joint tenants carefully. I've said it again, I'm going to say it again. Next slide.
Can I ask a question?
Sure.
With joint tenancy, so if there's creditors, they could come and take everything out of the account too, right? Even though it belongs to two people? If one of them has bad credit?
Yeah, the question is, if one of the joint tenants has bad credit, can the creditors take the money? And certainly the answer is yes. The joint tenant gets involved also. She talked about potential college applications, things like that, college scholarships. The answer is your joint tenant is going to be deemed as owning that asset. So creditors can take it. It often gets involved in a joint tenant, and that child's now embroiled in a divorce. That asset's likely to be drawn into the divorce.
And what about liability from an auto accident? They can come after that money too, even though
yes,
half of it belongs to the person.
Yeah, but that's not. I'm not going to agree that only half of it belongs to them. Okay. Next slide. So today we have, a slight change, I think, in the landscape. We have single parents that are involved in estate planning. The circumstances are obviously different than husband and wife that are married. We want to make sure that we provide for minor children in either husband and wife standard marriages, or if a single parent has children, that they might have either conceived differently, in and out of marriage scenario, or alternatively, post-divorce, depending on the custody arrangements and things like that. So it requires some considerable thought. Next slide, please. Next slide. Stepchildren, if you die without a will, your stepchildren will not inherit anything unless they're legally adopted by you. So if you want to provide, again, multiple marriages, you want to provide for stepchildren, you need to provide for it in writing in a will or in another fashion of owning assets that we've talked about, joint tenancy, things of that nature. So in Illinois, what we call the rules of intestacy, which means you die without a will, they do not include stepchildren. In Illinois, if you die without a will, your assets are going to go to your spouse and your children, regardless of age and regardless of need. Most people that are married want all of their assets to go to their spouse, who perhaps is going to take care of the children. Maybe the children are adults now, they don't need the money, but the issue is if you don't do a will, the state of Illinois and every state, no matter where you live, has already written a will for you. They're going to tell you how to distribute your property. You write a will, you decide how to distribute your property. Next slide.
Who does it go to if everybody that you leave it to predeceases you? Then who does the
court will use its best efforts to find your probably distant cousin that you never wanted to inherit the assets.
If I give a will, but my husband does not have a will, how does that affect me?
Well, your assets, if you own any in your name, are going to pass by your will. His assets are going to pass by the laws of intestacy or descent and distribution. So it depends on how the assets are titled. If you own everything jointly, it's probably a better scenario, but again, I would get in his face. Tell him to get it well. Okay, thank you. Next slide, please. So again, in Illinois, we have potential non-married couples. If you're not married, cohabitating with someone, get your estate plan done. Your cohabitating individual, whether it's man and a woman, two men, two women, it doesn't matter. They will not inherit from each other unless they own assets in joint tenancy, payable on death, or they have a will and or a living trust that provides for their inheritance. This is pretty important in kind of the changing world that we're living in. Next slide. Next slide. Again, same-sex couples in Illinois, same-sex couples have the same rights as a heterosexual couple married, so you can inherit from your marriage partner. Non-marriage partner, you won't inherit. Next slide. So, this is where it gets scary. Most estates run smoothly and are often completed and closed without any issues. However, when families don't get along, and a lot of families don't get along, you can think about your own family. That's when the complications arise and we end up battling in the courthouse. Next slide, please. So probate, we've talked about it, in excess of $100,000 in assets, court supervised, 6 months minimum. Creditors have 6 months, and you need to be supervised in general by the court. Should that your executor be allowed to sell the house? Well, one person says no, one kid says yes. It's going to be a contested matter in front of the court. If you can avoid it, you want to avoid it. Yes, ma'am.
How much does it cost to probate? I mean, in the courts? I know it's probably different based on
most lawyers bill it hourly.
Like
So
the court cost, is it?
the court costs themselves probably $250, $300.
Okay, maybe.
But that does not include legal fees.
Okay, I was just curious if it was a long
Yeah, it's not a huge amount of money, but you have to publish for creditors also. You have to literally put it in a newspaper. In Chicago, we use the Chicago Daily Law Bulletin. In all the surrounding counties, each newspaper area, you have to publish for creditors. So creditors are, literally banks particularly have people that do nothing, what a great job, but read obituaries all day long. Okay?
Wow.
And they're looking for their customers to see if their customers have loans that are unpaid to the bank. And then they go in and file a claim against the estate. They may even open the estate to get a forum to file their claim for an unpaid loan. Next slide. So we talked about basic two methods of attacking a will and or trust: undue influence, lack of capacity. This is a slide that has some more detail in terms of those types of attacks on the documents. Next slide. King of rock and roll, Elvis Presley. Elvis started off with, he's dead like 50 years now. Hard to believe he had $10 million, all for shaking his body. $10 million, he had a lot of expenses, And you can see what it ultimately left to Priscilla. Not a whole lot. Okay? Avoid probate if you can. Next slide. So, most importantly, I think, since we have about 2 minutes left, tell someone you love and trust where your documents are. Okay? If you're going to go through the aggravation and the expense due documents, let somebody know where they can be found. Next slide. As I mentioned, I don't think you need to be wealthy to do estate planning. Your takeaway is, does your will or trust match your current wishes? Your current wishes. Did you have a falling out with somebody that you want to cut out of your estate? Are your assets titled correctly? Have you funded your trust? And are you still comfortable with the agents you've named under your powers of attorney for healthcare and or property? Next slide. So, I want to thank you all for coming. I want to introduce my assistant, Lauren. Lauren is manning our booth next door here in the room. If you'd like more information about our law firm, please head over there. We have some great handouts. And we look forward to talking with you. We offer initial consultations at no cost. And you can do them remotely, by Zoom. You can do them in person. We have offices in Oak Brook, Northbrook, and downtown Chicago. Thank you very much. Thanks for coming to today's event. Have a wonderful day.
Thank you.
Back up.